So let's start chapter 7. We are talking about the elements of a contract. So a contract, to be a valid one, it requires 5 elements. 2 of them you saw in chapter 6, which was consensus, a valid offer, and an effective acceptance, and consideration, the price to be paid or the mutual benefit. So now here in chapter 7, we'll look at the other 3 remaining elements for a valid contract, which are capacity, legality, and intention. And we'll also take a look at the written requirement for a contract at the end of this chapter. So let's look at chapter 7. Let's make it. So what is capacity? Capacity is related to someone or an entity, a company, or a corporation that has full capacity to enter into a contract. So in general, everyone has capacity to enter into a contract. However, the law understands that some parties, they are more vulnerable to enter into contracts. So what the law says is the law tries to protect some parties. And they protect those parties by either limiting their capacity, their ability to contract, or eliminating completely. So we'll see some examples of those. And there's one thing before I go to those examples. So I told you 5 required elements for a valid contract: consensus, consideration, capacity, legality, and intention. However, capacity doesn't make a contract invalid. It does make a contract voidable. And you saw voidable in chapter 6. But I'll explain this voidable again. So voidable is when a contract is valid in principle, but there may be some issues with the contract, such as capacity or other issues we'll see in chapter 8, in which the contract may be ended, may be cancelled. A void contract is different. So see, first I explain voidable. A voidable, as I said, is a valid one, but may be cancelled. A void contract is different. A void is a null contract, is a contract that doesn't exist. So keep in mind that capacity, when there are issues with capacity, the contract becomes voidable, meaning in principle valid as long as the other 4 requirements are there, but may be cancelled by one of the parties. So the first issue we look at is minors and infants. So here in BC, you are a minor until you are, before you turn 19. After you turn 19, you become an adult. So when you are a minor, or when there's a minor in a contract, it means that the contract is voidable. Again, valid, in principle valid, but may be cancelled by the minor. However, it is not voidable for the adult or for the other party, for the company, for the corporation. And why? Because the law understands that minors or infants, they need to be protected by the law. So again, in principle, if a minor enters into a contract, they purchase a bicycle, let's say, at Walmart, the contract is valid, but because the minor is one of the parties, the minor may cancel the contract because, as I'm saying there, it is voidable by the minor. There are some exceptions to those. And the main exception for us here in BC are contracts of employment and also contracts for student loan. So whenever a minor enters into a contract of student loan or of employment, they are binding on the minor as well. So the minor cannot cancel or void that contract. So what is the lesson we get here? What is the real applicability of this? The real applicability is that if you, as an adult, sell something to a minor, it means that the minor may cancel the contract. You, the adult, you cannot enforce that contract. So if you sell your smartphone to a minor, make sure you get paid right away. Because if you deliver your smartphone, but you don't get paid today, maybe you get paid in a week or 2 weeks, and the minor doesn't pay you, you cannot sue the minor because this agreement is not binding on the minor. So this is the main lesson. I am not saying the minor will not pay. It may be the case that the minor pays you. But what I'm saying is that the contract is voidable by the minor if the minor wants. The only exception, as I said, if it is student loan or contracts of employment. So that's the main lesson here for minors when they are in contract. Okay? Whenever a minor becomes an adult, then if they keep on using the services or if they have the products under the contract, then the contract becomes binding. So let's say a minor signed a contract for a gym club when the minor was 18, and now the minor turned 19 last week, and the minor keeps on going to the gym. So then the contract becomes binding because the minor is now an adult. There's no more the possibility to make it voidable. In other words, this means ratification. So the minor ratifies, the minor confirms that agreement. Okay, so that is ratification when the minor becomes an adult. How is it going so far? Is it going okay? Any questions? All right. So are parents liable for the minor's contracts? No, parents are not. Parents are not. Parents will only be liable if they sign the agreement with the minor. So now I am a gym club owner. The minor came to my gym club to sign up as a member. Because I've taken this course, I know that the minor may void the contract because the contract is voidable. So I tell the minor, hey, go home, come back here with your parents. I need them to sign the agreement with you. Legally speaking, what I'm doing, I'm having the parents liable for that contract in case the minor does not comply with their obligations. So parents are only liable for the minor's contracts if they guarantee the minor's obligation, if they sign together, or if the law says like this. Okay, so that's an exception for parents' liability, but the general rule is that parents are not liable for the minor's contracts, nor are parents liable for the minor's torts. And but here the idea is to bring torts and contracts all together, because the minor is not bound by their agreement, as I told you. It is voidable on their side, but sometimes the other party, the company, the adult, they try to sue the minor under tort. So if the minor, let's say the minor rented a car. Renting a car is a contract. For whatever reasons, the renting company allowed the minor to rent the car, and the minor caused losses to the rental company. The rental company cannot sue the minor because contracts with a minor, they are not enforceable, except when student loans and contracts of employment. So to get away of this restriction, companies, they try to sue under negligence, under torts, but they can't. The law says that if the tort is related to a contractual relationship with a minor, that cannot be used to get away from the contract restriction. Okay, so that's also very important in terms of torts and contract law. So this we go on. So those were the main issues about minors. But the law also protects people who are insane, either temporarily insane or permanently, and also drunk or intoxicated. The rules for insanity and drunkenness, they are the same. So here, it is very important to understand that if one party is insane, again, temporarily or permanently, or intoxicated, they may get away from the contract they entered. But there are requirements for this. And there's a misconception here. People usually believe that if they prove they were insane or drunk or intoxicated, they can get away. No, that's not the only requirement. There are three requirements that have to be met. And yes, the first one is to prove you were either intoxicated or insane. But the second requirement is very important. The other person, the person you entered into the contract into with, that person, that company, they need to know you are insane or intoxicated, or they should have known you were intoxicated or insane. Because if they were not aware, if you were not showing any signs of insanity or drunkenness or intoxication, they could not know. And then, if this is the case, you are still bound by the contract. Okay? So let's say you are drunk, you are at a casino, and you are drunk, and you want more money to play more. So you sell your 1,000 smartphone for $100. The person you sold it to, they knew you were drunk because they saw you drinking the whole night. So in this case, your chances to get your smartphone back would be higher. However, if there was someone passing by you and you were still drunk, however, you were not showing any signs of drunkenness, and they purchase your smartphone for $100 because you would have a hard time to prove the second requirement, it is very possible that you cannot get your smartphone back. So remember, you have to prove you were actually insane or intoxicated. Second, the other person or company knew or should have known you were. And there's a third requirement, that is, you need to try to repudiate. What repudiate means? You need to try to cancel the agreement as soon as you become sane, as soon as you are not intoxicated anymore. So those are the three requirements. The three requirements have to be met. Then your chances to get your smartphone back, in my example, they are higher. Let me just get the question here from Alexander. So if the minor got problems with police, law, who is responsible for that? His parents? Well, first of all, Alexander, this is criminal law. And criminal law is different. The concepts there in criminal law are different. But I'll just tell you a little bit about this. No, parents are not liable for their infants' criminal acts, even torts. Parents are only liable if the law says so. And in most cases, the law doesn't say anything. I'll give you an example when the law says parents are liable. The School Act, the legislation for schools, says that parents are liable for their children's losses, damages at the school premises, but up to $10,000. So let's say a child caused a loss at a school of 1 million, put fire on purpose. So the parents are liable only up to 10,000. What about the 990,000? The school would need to sue the child. But the child has no money. Well, you saw that in chapter 2, chapter 3, actually, there's no way the school would be able to get money. Okay, so no, parents are not liable. All right, moving on. So there are other parties that have limited capacity. Corporation, for example, companies in general. So when you start a company, you and partners, the shareholders, they may decide that a company will not do business with the government, or they may decide that the corporation will not do business, will not get loans from the banks. So whatever the corporation, the shareholders decide, they are actually limiting the capacity of the corporation. If there isn't such a limitation, then the corporation has full contracting capacity. But if there's a limitation in the corporation's documents, then that limitation has to be complied with. Also, crown bodies. Crown bodies, governmental companies, they have their capacity. They may have their capacity limited by the legislation that created that company. So here in BC, we have the Insurance Act, and the Insurance Act created ICBC. I haven't read the Insurance Act in full, but there may be some limitations for ICBC. There may be some transactions in which ICBC does not have capacity to contract. How do we know this? Well, we need to look at the legislation. We need to look at the act in question. So those are other limitations in capacity. We also have foreign governments, foreign aliens, unions, and here I want to just emphasize the Indian Act. The Indian Act says that a property of indigenous people, their property, their land, they cannot be used as security. They cannot be seized and sold by the creditor. So how do we, this is limiting, this is a type of limitation. And how do I use this in real life? Well, if I am a bank manager and there's indigenous people coming to my table to negotiate a loan, and I ask them to offer something as security, because if they default payment, I want the security to be seized and sold so I can recover some of my loss. And then let's say they offer me their land. Again, because I know the law a little bit, I know that their land cannot be seized and sold. So my answer to them is, hey, I'm sorry, but because of the Indian Act, I cannot have your land as security. Do you have anything else? Do you own a car? Do you own jewelry? Anything else? But not your land, because there's a limitation. Okay. So are we good with capacity? Mostly on land. No, there are more. So the question is, the Indian restriction is on land only? No, mostly on land, but there are other restrictions. There's several restrictions, not only for contracts, but some for other issues as well, because the government, the Canadian government, is trying to catch up with what they have done in the past to indigenous peoples. But what is mostly important for us is this limitation on property. And eventually, if you want to go further and deeper into those limitations, you should then read the Indian Act more thoroughly. Okay. So this question, this is a question that is similar to your exam, not the same, but yeah, similar. So you want to try this? I could create a poll here, but it would take some time. So you can use the chat to answer if you want. If you don't find, but Which one do you think is the right answer? Exactly, that's B. Only the student loan is binding on the infant. The other ones, they are not binding. And again, am I saying the infant will not comply with their obligations? No, I'm not saying this. What I'm saying is that in case they don't, the other party cannot enforce the contract, cannot sue them. That's what I'm saying. So that's why you have to be cautious when you are doing business with an infant. Okay? Because the law protects them. All right, moving on. How are we going so far? Are we going okay? All right, so now let's look at legality. So as of now, you know that a contract is valid when there's consensus, when there's consideration, when the parties have capacity, and now the fourth requirement, when a contract is legal. And in terms of legality, there are two issues we need to be cautious about. First one is when the contract is performed illegally. See here, performed illegally. The other situation is when the contract is formed illegally. So those are two different things. Why? Because if I'm saying the contract is performed illegally, sorry, it means that the contract was first formed legally, but then while performing the obligations, this performance was illegal. Okay? So those are two different things. Let's first look at formation. When a contract is formed illegally. So a contract is illegal, is formed illegally when the object is illegal. Drug deal, prostitution, those are illegal objects for agreements. So this makes a contract to be illegal. And when a contract is illegal, the consequence is that courts, they will not help. They will not help. Because you should know, people should know, parties should know that the object is illegal. So they could not enter into the agreement. So let's say last week I ordered some drugs through Uber Eats, and I used the drugs, and the drugs were not good. The quality was bad. So I wanted to sue the drug dealer. And see, this is a joke, but I wanted to sue the drug dealer. I could not. Why? Because drug is an illegal object, meaning the contract itself is illegal. Okay? So courts, they don't help parties when the contract is illegal. However, the other situation is when a contract, and by the way, let me give you other examples here. A contract to commit a crime. So let's say you don't like your neighbor and you hire a professional killer to kill your neighbor. That contract is illegal. Okay? Courts will not help you, nor will they help the professional killer if there are any issues in the contract. And there are other examples in here. Fixing prices, such as cartel. Let's say all gas stations in Vancouver, they decide to have gas for $1. All of them. So they are fixing prices. They are going against competition. This is illegal. Okay? So those are all examples of illegal contracts. We should know what an illegal contract is because if we enter into one, courts will not help us. Okay? We are taking our risks, we are taking our chances. But coming back to contracts that are performed illegally, this is different because the contract is legal, the contract itself is legal, but performance is illegal. Let me give you two examples because there are two different consequences. Well, first of all, if the illegality cannot be corrected, then the contract is void. The contract is inexistent. and the court, they will restore the parties. So what I'm saying is, let's say you hire a dentist, but the person claiming to be a dentist is not a dentist. And here in BC, here in Canada, only dentists can deliver dental services. So this illegality in performance, because a dental service contract is a legal contract. However, it can only be performed by a dentist. What I'm saying is, if a person claiming to be a dentist is not a dentist, so that contract will be performed illegally. If you are in such a situation, the courts, and then you sue the person because you want your money back, then the courts will say, okay, fine, I will order that person claiming to be a dentist to give the money back because you entered into a legal contract. However, performance was illegal. That is one situation. But the other situation is if the illegality in performance is only procedural, is usually minor. And the best example here is construction. So you have your land and you hire a construction company to build your house. The construction company starts building your house, but they haven't acquired a building permit yet. But they will. It's just taking some time. So let's say you want to sue them for any other issues, or they want to sue you. The fact that they are building your house, they have started already in an illegal way because they don't have a building permit yet, is not a big issue for the contract because that illegality can be corrected. This is just a procedural violation, as I'm saying. This is different from the dentist because a person who is not a dentist cannot correct this in a day. The person will need to go to college, etc., to become a dentist. But a construction company, no. A construction company, they may be acquiring the building permit, but just to save time, they want to start building. So that would be a legal contract because construction service is a legal one. However, performance would be illegal for some time. Okay, so those are two different circumstances with different consequences. And again, this is related to a legal contract being performed illegally, which is different from an illegal contract in which the object is illegal, such as those examples in here. Okay, I have a question here. Can contracts be only drafted up by lawyers? No, not at all. You can just go online, search for any type of contract you want, and use that contract. However, to offer a legal service, to draft a contract, to review a contract, to negotiate a contract, this is restricted for lawyers. So only lawyers can sell a service that is related to drafting a contract. Okay? But it doesn't mean that all contracts, they have to be drafted by lawyers. No, people can use any contracts they want. Was I clear? Did I answer your question? All right. So the next topic is related to restrictive covenants. Restrictive covenants, they are restrictions. They are clauses or sections in a contract that restrict one of the parties to do something. And then you could be thinking, how could this be? Well, let's say I am purchasing a new business. I'm purchasing a pet shop that exists for 10 years now, 5 years, and I'm purchasing this pet shop. As a buyer, I don't want the seller to start a new pet shop just next doors. I don't want the seller to be competing with me, for example, because they may attract all the former clients. So a non-competition is an example of a restrictive covenant. Or there are other examples, such as confidentiality, when people cannot disclose confidential information. So confidentiality clauses, confidentiality sections, they are also known as restrictive covenants. And let me just see. Yeah, it goes on. So what we need to know here is that a restrictive covenant, to be valid, they have to be reasonable. How are restrictive covenants reasonable? Well, they are reasonable whenever their time limitation and geographic limitation are reasonable. In other words, in my example, so I'm purchasing this pet shop. I don't want the seller to compete with me. So the limitation in time has to be reasonable. So I don't want the seller to compete with me for 2 years, for 1 year. But if I have for 10 years, for life, those are not reasonable limitations. Also geographic limitation. So I don't want the seller of the pet shop to compete with me anywhere in BC. This is not reasonable for a pet shop because there are pet shops everywhere. And I'm buying the pet shop that is located downtown Vancouver. So yes, I can restrict downtown Vancouver for some time, for 2 years. But I cannot say the lower mainland. I cannot say all BC or all Canada. Okay? So it varies on what the transaction is. But based on my example, the pet shop, you can understand the limitation in time and also geographic limitation. So the question here, what is restrictive clause? So restrictive clauses are clauses that will restrict, that will prohibit one party to do something. And the examples I gave you was confidentiality, which is not disclosing confidential information, or non-competition, the pet shop example, not competing with the buyer, for example. So those are examples of restrictive clauses. Okay. All right, moving on. So this is the last element. And I like to repeat this when I'm in class because I think it helps students to memorize. So the 5 required elements for a valid contract: consensus, consideration, capacity, legality, and now intention. Intention says that, well, parties, they need to intend to that transaction. They need to intend to those obligations, to those benefits. This is intention. But intention as a requirement is very easy in law. Why? Because in business situations, commercial relationships, there's a presumption of intention. So it's presumed that intention is there. So that is easy. So if you go to Tim Hortons and you buy coffee, there's an intention. There's presumed intention. What is this presumed intention? Well, it's presumed that you intended to pay for the coffee, and it's presumed that Tim Hortons intended to get the money for the coffee and deliver you the coffee. So no one would challenge this intention requirement in a business relationship. However, intention as a requirement is very important in family relationships, in social or domestic relationships. What are those? Well, let me give you some examples of social relationships. Clients and professionals, lawyers and clients, dentists and patients, doctors and patients, realtors and clients. Those are examples of social relationships or domestic relationships. Parents and children, grandchildren and grandparents, aunts, uncles, cousins. So those are family relationships. Here, for social or domestic relationships, there is presumption of no intention. So here's the opposite of commercial relationships. What I'm saying here is, if I sell my car to my daughter, it is presumed that there was no intention. And if there was no intention, the contract is void. The contract is not legal, is not valid. So here, the key message here for intention is related to social or domestic relationships. If a lawyer sells a car to their client, again, there's a presumption of no intention. However, the presumption here is not absolute. The presumption here may be rebutted. The person entering into the agreement, they may show proof that there was actually intention. So let me give you this example. I'm selling my car to my daughter. As I just told you, the law says that there's a presumption of no intention. However, if I have evidence that, first of all, my daughter actually needed the car. Second of all, she paid a fair price. Third of all, she had an opportunity to seek legal advice, independent legal advice. So those are all characteristics or evidences that would rebut this no intention presumption, that would show the court, if needed be, that there was actually presumption. Sorry, there was actually intention in this transaction. Is that clear? All right. So one more question for you to practice what we are discussing. So all contracts here are illegal, except one. Which one is this legal contract? C, prostitution, sexual favors. Oh, this is an illegal contract. And we are looking for the legal one. E, the lawyer agrees to represent an accused where the accused did commit a crime. Yes, E is the correct answer. No, don't be sorry. It's fine. This is the proper place to make a mistake. Don't worry about this. I just read and explained because it requires explanation. But don't be sorry about this. So E is the correct one. Why? Because in E, actually the contract is a legal service contract. It doesn't matter if the accused committed a crime or not. This is related to the prosecution. What matters here for us is the nature of the contract, the object of the contract. And the object of the contract here in letter E is legal service. So yes, E is a legal contract. All other options, A, B, C, and D, they are illegal contracts. They have illegal object matters. Is that clear? All right, so moving on. Form of contract. So you may remember from chapter 6, and this is very important, that verbal contracts, oral contracts, they are as valid as written contracts. They have the same validity. The problem is that with an oral contract, it may be more difficult to prove. So if you need to sue someone because of an oral contract, it may be difficult to prove, but not impossible. You may have witnesses, you may have a recording, etc. So what you need to understand, what you need to remember and memorize is that oral contracts, verbal contracts are as valid as the written ones. Okay. However, some types of transactions, the law requires the contract to be in writing. Not the contract. There has to be a written evidence, a written piece. The law says this. The law understands that in some types of transactions, written pieces are needed. Okay? So, and what are those types of transactions? The one you should remember is transfer of land. So, whenever you're buying a house, you're buying a land, you're buying an apartment, any land, any real estate requires a written piece. And I'm saying written piece, I'm not saying the contract itself. Why? Because actually the law says there has to be something in writing. The essential terms, they must be in writing. So if you're buying a house, what are the essential terms? Well, the address of the house, the price, and the payment terms. Those are the essential terms. So let's say you and I, we are having a lunch and you want to sell me your house, so we can get a napkin. We can write those essential terms down in the napkin. We both sign and we comply with this written requirement. Yes, in most cases, there will be a written agreement. But what I'm trying to convey to you is that it is not only the agreement that has to be in writing. It can be anything in writing. Could be a receipt, could be a note, could be in a napkin, as I said, could be an email, or the best scenario is the agreement itself. Okay, so you could also you don't need to memorize this list, but those are more examples of contracts that the law requires them to have a written piece. Okay, so transactions that are longer than 1 year. Let's say you have a company, you are the owner of a franchise, Tim Hortons, and you have a contract with a napkin supplier. The contract is valid for 5 years, 10 years. So that contract, because it is longer than 1 year, this contract has to be in writing, or there has to be a written piece. Transfer of land and some others. Okay, so you can just remember those two that are important. And the consequence here, those types of contracts, if they have no written piece, it doesn't mean they are invalid. No, they are still valid. The consequence is that the courts will not enforce them. So again, my example, I am buying your house. If we have no written piece and there are any issues in our contractual relationship, I cannot sue you or you cannot sue me. Why? Because the courts, they will not enforce a contract that should be in writing, that should have a written piece. So that is the consequence of a contract that should be in writing and is not. Only about enforceability. It is not related to validity. Okay? Keep that in mind. That is important. One last thing, electronic contracts, this is just straightforward. They are valid, they are legal, and we have been using them a lot nowadays. So one last thing is that part performance. What does this mean? This means that a contract that should be in writing, such as the transfer of land or longer than 1 year, as I just said, if they are not in writing, but there's partial performance. What is partial performance? Well, if I purchased your house and you allowed me to move in, if I purchased your house and I paid a down payment or I made a deposit, this is partial performance. So when there's partial performance, even though there's no written piece, the courts will enforce that agreement. So part performance actually helps when the contract that should be in writing is not in writing. Is that clear? So we should have a written piece. We do not, because we forgot or we didn't know, etc., etc. However, there's partial performance. There's a payment, there's any obligation that was performed, then the courts will enforce that contract. So that was the last important piece here. So as I said, contract formation. Again, a contract requires 5 elements to be valid. See there, but actually 4, mostly 4. Capacity, as I said, in most cases, the contract is voidable, not void. Could be void with insanity, but mostly voidable. However, the other consensus, consideration, legality, intention, they make a contract either void or invalid. Okay, so those are the 5 required elements for a contract to be valid. The last question for you, and while you think about this question, let me see. I have a question from Alexander. What about online agreement or Facebook or Instagram? Yeah, they are valid. Online contracts, they are valid. They are electronic contracts. And once you click on I accept, so when you accept the terms and conditions, you have entered into the contract. Is there any resource for contract sample? Well, I did have one. I did use contractstandard.com, but yeah, if you Google contracts, you can get any one. But I can let me write down in here. If I'm not mistaken, is contract standard.com. If I'm not mistaken, it's been a long time I don't use it. But see, as an instructor and also as a foreign lawyer, I cannot give you any legal advice. So I'm just sharing this with you all, but not in a legal advice parameter. Okay. But yeah, if I'm not mistaken, is this contract standard. And if I'm not mistaken, when I used it, it was a free resource. You do need to register, but then once you register, you can use it. It was free. So here, the right answer is B, false. All contracts must be in writing, but must be written to be binding. Yes, the answer is right. It's a false statement. This is a false statement. I just told you. Verbal agreements, oral agreements are as valid as written ones. Okay? Except for some types of transactions, as we just saw. Is a text message valid? Well, it may be a valid contract. What is required actually is that the essential terms are there. So if I text you, again, I'm selling you my house. So if I text you the price of the house, the address of the house, characteristics of the house, and payment terms, and you reply back and you say, yeah, done. Yeah, it may be regarded as written evidence for a valid contract. Definitely.